I think one of the common difficulties we come across by yourselves and directly is clients that own additional properties that want to plan for inheritance tax, maybe capital gains tax, or ultimately want to maybe give these assets away. Now, often secondary additional rental properties, so as they've accrued and increased in value, not only has a client earned some good capital appreciation, they've also probably had a good living from the rental income as well in the growth phase. But when the growth phase comes to an end almost, and the clients are looking to consolidate and maybe reduce the value of their estate for inheritance tax, this capital gains tax hurdle is a really difficult one to overcome. Now, this won't be for every client, but clients often, mum and dad, grandparents, we find, own properties where they've allowed their children, grandchildren or other relatives to potentially live in. Whether they're paid rent or not does not matter, because when that property is sold, there's going to be a capital gains tax liability that's increased in value. Now, capital gains tax allowances have gone down and down and down, currently £3,000, and of course lots of properties, certainly in good areas, have increased multiple times over in terms of value. When you find a property within the client's portfolio where a family member has lived there, there's an opportunity potentially to be able to sell that property capital gains tax free. And that's through the use of a statute called Law of Property Act 1925, in particular section 53(1)(b), that allows a client who's got a verbal arrangement, i.e. I'll let you live in that property for as long as you want, you may pay rent, you may not. That is a trust, but it's not a valid trust until it's evidenced in writing. So a trust of land does just that. It'll evidence the fact that, let's say it's a parent that owns a property their child has lived in for 10 years, but now we're 10 years on, so looking to sell that property. If we draw up a trust of land confirming that arrangement, the agreement between the parents and the child that you can live in the house, and we can claim the gain as being exempt as the child's main residence. Section 225 TCGA allows us as trustees of a trust, if we permit a beneficiary to live in that trust, we can exempt the gains for the period plus 9 months as well that they've lived there. But that trust has to be in writing. So if you've got clients that might be in these circumstances, please contact us at CTT Group, because we just might have the solution.